Hi, I'm David Yaz of the Boston Podcast Network. I'm here today with attorneys Russell Schwartz and Nick Plante of Worcester's leading family law firm, Schwartz and Plante. So the topic for discussion for today is education law. So, Attorney Schwartz, I take it Schwartz and Plante handles education law cases.
That's right. About 3 years ago when Nick became a partner with our firm, he was able to bring some of his experience with him to allow us to develop this program that is now actively involved as a major part of our practice.
Well, tell us about it, Nick.
Generally speaking, we handle two different kinds of matters. The first would be what I call school discipline. So believe it or not, students who are disciplined in public schools have a right to an appeal process, which oftentimes can involve a lawyer. It can involve hearings before building principals, before school safety officers, and ultimately even before superintendents, school committees, and finally the Superior Court if a student's due process rights have been violated. So occasionally we have the ability to represent a student who's been disciplined, maybe in what we think to be, or the student and his family or her family believe to be an overly excessive punishment or discipline that wasn't in compliance with constitutional requirements or state law. The second piece that we do, which is what we do much more of, is we work with a number of special education students with respect to the development of an individualized education plan, commonly known as an IEP. Under federal law, students who have special needs or who have been determined to require certain modifications to the educational curriculum that they're receiving are entitled to certain things from a school district. And as a result of that, there's what's called an IEP team. And that team develops an individualized education plan for that student with special needs. That process, attending the initial team meetings, participating in the development of the plan is something that we do. And there are occasions when the team members, which include the child and the child's parents, are not on the same page as the school department. And so there is in Massachusetts what's called the Board of Special Education Appeals in Boston, and they are essentially a quasi-judicial agency, or an informal court might be an easier way to explain it, that hears those appeals. And so we represent parents who appeal to that board because they can't agree with the school district as it relates to a number of things related to the child's individualized education plan.
A lot of special needs parents might not realize they can consult a lawyer because lawyers, I think, are fairly rare in these IEP meetings. I've been to some myself. So I take it if someone's wondering whether the school is continually giving them insufficient services for their child, they should consult with you, and you could possibly step in.
They certainly should, and we also have a stable of experts that we rely on too. Special education teachers, reading specialists, neuropsychs, all types of people who we use as experts to help us determine what that student needs, what accommodations the school can make, and we can review existing 504s, we can review existing IEPs, we can review existing testing, we can help, for lack of a better word, prescribe a course of testing that we'd like to see happen to further analyze the student and what the student might need, and then certainly participate in the IEP team meetings as well as handle the appeals, but absolutely.
And just to return for a moment to the subject of typical student discipline, when should be the moment where typically a parent, I guess, should give you a ring when they feel that the child has been aggrieved in some way? Or
It's a great question because there are actually some time frames. Really, ideally, if a parent feels as though the student's rights have been violated or the discipline is excessive, they should reach out to a lawyer right away because there are some pretty rigid time frames with respect to appealing those decisions, some as short as 10 days. So we want to be able to file our respective notices to appeal those disciplines because there are some discipline decisions that if not appealed within that very strict time frame will become permanent and there's nothing we can do after that. So almost immediately upon the imposition of the punishment.
Well, thank you both for the crash course in education law, and it's good to know that folks can come to your firm for answers on these delicate questions. Thanks for listening to today's discussion. For more information on this topic and all topics surrounding family law, and to follow up with attorneys Schwartz and Plante, please visit the website at schwartzplante.com. And thanks for watching.